There is an idea that the United Nations Charter would have an international bill of human rights. And there was no time, and the Commission on Human Rights, when it met in 1947, it committed itself to the project to establish an international bill of human rights that had three parts: the Universal Declaration, the covenants, and measures of implementation.
Contemporary international law now takes as a given that human rights are universal, and it implements this belief through a set of rights that are declared as being applicable to all in all times and in all spaces, and constitutes, according to the terms of the 1948 Declaration, a shared ideal to be achieved by all nations.
Its founding document, the International Covenant on Civil and Political Rights, is, alongside the Universal Declaration of Human Rights, the central reference point for civil and political rights. The Human Rights Committee serves as the most important promoter for the implementation of the Covenant and the rights granted therein. Germany believes that especially the deep and thorough analysis of state reports and the open discussion with states parties are of particular value in this regard.
Insofar as the reporting system is concerned, by means of its concluding observations, the Human Rights Committee has, along the years of its operation, contributed to give precision to the scope of the rights protected under the Covenant, as well as to the corresponding obligations incumbent upon states parties.
When examining the periodic reports of the 166 states parties to the International Covenant on Civil and Political Rights, the committee time and time again makes concrete recommendations which have led states to change their legislations, policy or practice. Since the establishment of its follow-up procedure, implementation of these recommendations is being carefully scrutinized by the committee, making them even more effective.
It would, for example, be most welcome if the committee, when it confronted with a clear situation of violation of the provisions of the pact by a state party, says so clearly in the concluding observations. Indeed, the committee, as a supervisory body of the Covenant, must specify in what way states are not living up to their obligations, and this is not always clear in the concluding observations.
The committee needs to make more precise and targeted recommendations on targeted measures so that the states themselves, but also NGOs and civil society organizations, to better follow through the recommendations and be able to quantify their implementation.
Of all of the treaty bodies, the Human Rights Committee has the most significant experience in examining individual complaints. As a quasi-judicial procedure, the committee has described its views as exhibiting some important characteristics of a judicial decision.
It will be important, as a matter of the greatest urgency, to consider how your core jurisprudence can be made available to judges worldwide in local languages. I had this on my mind at the time I left the United Nations, and I could not dent this. But I think that institutions such as the International Bar Association and the International Commission of Jurists can help in this endeavor.
There have been, in recent years, as pointed out in the debates this morning, successive judgments of the European Court of Human Rights which refer to the views adopted by the Committee on Communications. The point you made. I would add that, likewise, the Inter-American Court of Human Rights, ever since my years serving and presiding it until now, has referred in successive judgments to the views as well as the general comments of the committee.
Another important achievement of the committee relates to its adoption of general comments or interpretive guidance on the rights set out in the Covenant.
In its recent and lengthy General Comment number 32, the committee identified the right to equality before the courts and tribunals and to a fair trial as a key element of human rights protection and as a procedural means to safeguard the rule of law. In the committee's understanding, Article 14 of the Covenant contains guarantees that states parties must respect regardless of their legal traditions and their domestic law.
Specifically, general comments which provide solid legal analysis of civil and political rights have helped states to shape their positions thereon. This will also be the case for the upcoming general comment on Article 19. I believe will add significant value and help clarify views concerning the current intense debate in the Council on the concept of defamation of religions.
Many success stories have arisen following the implementation by states of remedies recommended in the committee's views. Such positive outcomes include commutations of the death penalty, early releases from prison, receipt of resident permits, and compensation to the victims of human rights violations. The numerous amendments to legislation to which many of the committee's views have contributed demonstrate the beneficial effects which successful implementation of views can have on the rights holders of an entire state.
I think national jurisdictions have used the international instruments to upgrade their laws. I think of Canada, for example, which applied the Covenant's decision not to extradite persons to a country where there is still a death penalty. So Canada followed the jurisprudence of the committee. And
precisely because there is an implementation gap and views are not always enforced, states should adopt enabling legislation so as to give committee decision status in the domestic legal order, may be similar to Colombian Law 288 of 1996.
We've failed to identify reparations as regards restitution, reparation, guarantee that there will be no repetition so that the states will uphold their obligations under the Covenant.
The committee should develop and make systematic its follow-up for key findings. Member States must commit to comply with its findings, and ensuring implementation should be a priority for the entire UN.
What I would propose that we do, therefore, is that we focus on the implementation of the legal instruments, including our covenant, and we should try to avoid the mushrooming of other human rights instruments.